So thanks everyone for attending today. I'm Nicole, our development and communications person. I'm going to be moderating this webinar. What that means is that if we run into problems, it's totally my fault. But actually, in all seriousness, this is the first time we're doing anything like this. And so I don't think we'll run into technical problems, but if we do, my apologies. Joining us as panelists, we have Deborah Gonzalez, Steve Brown, and Hannah Stern. Deborah currently serves as the director of the Immigration Law Clinic at Roger Williams University School of Law. She is also a practicing attorney and has served recently as cooperating counsel on 2 of our immigrant detainee lawsuits. Hannah is our policy associate here at the ACLU Rhode Island, and she also handles most of our research and data analysis. And then last but not least, Steve Brown, our executive director, needs no introduction really. So thank you again for attending, and without further ado, here's Steve Brown, who's going to start us off. I know he wanted to express his thanks, and then he's going to give a recap of what's happening on the voting rights front. Why don't you go ahead, Steve?
Sorry, I should know by now to unmute. I want to thank Nicole, thank everybody who's in this first town hall. As Nicole said, there may be some glitches, like somebody forgetting to unmute themselves, but we hope that this is really the first of many other town halls virtually in light of what's going on. I do want to give a few introductory comments before I go into the specific topic I've been asked to talk about. There's obviously a lot of stuff going on nationally, and we'll be touching on that at the local level. But one point I always like to stress is while there are really significant critical things going on at the national level, ultimately, you've heard the comment that all politics is local. I believe that all civil liberties is local. Congress can do things, the Supreme Court can do things. Ultimately, it's what happens at the state and local level that decides, how much constitutional protection we actually have. Because it's on the ground at the state and local level that the civil liberties issues often come to a head. And that's why, we're so thankful for your support of the affiliate as well as our national office. Now, these are very different and strange times, as demonstrated by the fact of how we're holding this meeting, event, whatever you want to call it. There is what I've called a perfect storm of civil liberties problems that we're facing, both locally and nationally. It's only natural, unfortunately. I think it's inherent in the nature of government that crises breed government repression. We're seeing that. We're seeing crises as a result of the pandemic. But then when you add to that the upswell of outrage, legitimate outrage over police abuse across the country, when you see what the federal government is doing in response to those protests, it really is a terrible perfect storm for violations of civil liberties. And it has kept the ACLU busy, not only nationally, but also here locally. Thus far, here in Rhode Island, we have filed 5 pandemic-related lawsuits. I'm sure there are more to come, and you'll be hearing about a few of them during this town hall. And that's what we'll be getting into in a minute. I think what's really gratifying, though, with all these crises going on, is how our affiliate, which is a very small affiliate, you're going to meet, you already have met one of the staff, you'll meet one other one. We've really been able to do a really good job pivoting and dealing with these crises and having to deal with them remotely. So it's been a great challenge, but and there are many more to come, but I'm confident that thanks to the support we get from you as members, thanks to the support we get from people like Debbie Gonzalez, who has put in an incredible amount of time as a cooperating attorney to help us with litigation. We're going to get through this. Somehow we're going to get through this, and we're going to address the civil liberties problems as they arise and hopefully resolve them in a favorable manner. And you'll hear on this town hall a few that we have been able to do that way. So let me get right into the topic that I'm starting with, and that's voting rights. Voter suppression has been a problem across the country for many years. It's been a problem here in Rhode Island as well. Rhode Island has the unfortunate distinction of being the only Democratic legislature in the country, for example, that passed the voter ID law, which we did back in 2011. And there have been obvious disruptions as a result of the COVID-19 pandemic. We saw that early on, as early as April, the ACLU, joining with a group of other organizations called the Voting Access Coalition, urged the state to take action in preparation for the June presidential primary, knowing that there were serious health problems with encouraging people to vote at the polls. Now, fortunately, state officials recognized those concerns and acted fairly expeditiously and agreed to a lot of the suggestions that our groups and others had. And so as a result, for the June primary, every individual who was listed as a voter obtained a ballot application. They were able to send it in, postage prepaid. They were able to drop off their ballots at drop boxes at local cities and town halls. And most importantly, for purposes of what I'm going to talk about, you did not need to get 2 witnesses or a notary to sign your ballot envelope in order for it to qualify. Rhode Island is one of only 2 states in the country that has a requirement like that. And it's obviously a burdensome one if you have to find 2 people to witness you as you sign the envelope yourself. And of course, it becomes extraordinarily dangerous when you have a pandemic like this, where everybody is talking about social distancing, not holding the same things that other people are holding, whether it's a piece of paper that you have to sign, whether it's a pen. So the danger is obvious. So when the June presidential primary ended up working very well by eliminating the witness and notary requirement, I think everybody was very pleased. From about 5% of ballots in elections being mail ballots for June, it was over 80% of the ballots cast were by mail. So we expected the same thing to happen for the upcoming elections. We have another primary coming up in September, and then of course the big November general election. Everybody was talking about the need to do the same thing as had been done with the June primary, but nothing ended up happening. The House of Representatives passed a bill that would have waived the signature requirement. The Senate, however, refused to take it up. The governor, who had issued an executive order to allow the waiver of the requirement for the June primary, took no action, did not issue a new executive order. And the problem was the Secretary of State's office was under a deadline to get the ballot envelopes printed, and she needed to know, were the instructions going to include the requirement that you get 2 witnesses? So when it was clear that nobody else was going to act, we very quickly put a lawsuit together with help from our national office and another national organization. Both the League of Women Voters in Rhode Island and Common Cause Rhode Island were eager to sign on as plaintiffs. And then we found a few individuals who really are practicing social distancing because they need to, because they're very medically vulnerable. We have an 88-year-old shut-in who has a number of disabilities. We have a 32-year-old blind woman who lives with her elderly grandmother who would likely die if she contracted the disease. So we had very strong plaintiffs indicating why waiver of the signature requirement was so important. So we filed an emergency lawsuit last week. The judge very quickly ordered a hearing on it, And I'm pleased to report that first, both the Secretary of State and the Board of Elections, who were the defendants in the case, agreed to a consent decree saying that they agreed with waiving the signature requirement. What happened, however, was at the last minute, literally at midnight on Monday or Sunday night, the Republican Party filed a motion to intervene in the case in order to defend the constitutionality of the waiver signature law. We had a hearing on that yesterday, and I'm pleased to report the judge rejected the Republican Party's arguments and agreed with the consent decree that the signature requirement would be waived. At this point, it's a great victory. We do have to hold our breath because the Republicans have indicated they're going to appeal, but we're hopeful that ultimately we will succeed and we'll be able to have a much more safe election than we otherwise would in light of the pandemic. So that's just one example of the work we've done and as a result of the pandemic. And I'll turn it back to Nicole to get us to the next one.
Thanks so much, Steve. Next up, we're gonna have Deborah Gonzalez, who's gonna share some information about our recent legal victories on behalf of immigrant detainees at Wyatt. Let me just make sure I don't. Oh, sorry. I kept muting you, I'm sorry.
That's okay. Can you hear me?
Yes, yes.
Well, thank you, Nicole and Steve and Hannah, for inviting me to speak at this town hall, at this meeting or gathering. I guess this has now become what we do. Instead of driving to a place where we meet and see each other in person, we now sit in our dining rooms or offices or whatever, and we meet via video. But I, for one, am looking forward to seeing everybody in person again and having to drive someplace. I won't mind that when the time comes. So I got involved with the ACLU back in March as soon as the governor had put in place her state of emergency and everybody was staying at home. I got an email from a colleague of mine, Jared Goldstein, who is also a professor at Roger Williams University, who had gotten the call from Steve actually to see if he would be willing to represent or contact one of the detainees that had been sitting at the Wyatt. So when we first started this in March, COVID was just, I think the nation itself was just kind of now realizing that COVID was inside of the United States. And even though, you know, the president didn't say anything or even sound the alarms, you know, it was finally in March when this happened and we were getting calls. We had been hearing about in the news the congregate living spaces of cruise ships and nursing homes and how people were getting sick, and the spread of COVID was, you know, running wild. And of course, detention facilities and prisons are no different. And so we had gotten the call, or Steve actually had gotten the call from the wife of one of the detainees who was being held at the Wyatt, and he suffered from asthma, and his wife was really concerned. He had severe asthma, and his wife was really concerned that that he was going to contract COVID. At the time, the Wyatt had not reported any cases. We had been hearing of a few cases at the Adult Correctional Institute in Rhode Island, which holds state prisoners or people who are waiting for their pretrial for their criminal cases, but we hadn't really heard anything from the Wyatt yet, albeit there had been individual lawyers that had been filing habeas petitions for their clients for fear of COVID. So I reached out, once the connection was made, I reached out to the client, and we ended up identifying 2 more plaintiffs because we didn't want to go forward with the case with just one plaintiff. And by then, we had contacted a couple of other folks through the ACLU National, and they have been really a godsend for me and for Jared with all of the assistance they've been giving us. And we've had resources with other COVID cases that have been going on nationwide, like the one that's going on against Bristol County House of Corrections in Massachusetts. There's another one in New Hampshire, that's Stratford, that was going on there. And I believe there's another one that I'm aware of that's going on in San Francisco or somewhere in California. Maybe I might be misspeaking, it's just San Francisco. Anyways, so we had a lot of resources from ACLU National, which was absolutely awesome. Because certainly, you know, I'm a volunteer lawyer with the ACLU, and not knowing anything about this, I'm an immigration lawyer by trade, and that's what I practice. I don't practice federal litigation, but this was an easy one to get involved with. And so we ended up representing 3 different plaintiffs, and that case was called Medeiros v. Martin, wherein we had filed our first habeas on 2 legal grounds, right? 2 constitutional issues under the 5th Amendment and the 8th Amendment, right? The 5th Amendment being that because immigrant detainees are civil detainees, right? They're being committed civilly, not because of a crime. Their detention can't have a function of punishment, meaning that, you know, the detention can't be for the purposes of punishing. The detention needs to be solely for the purposes of actually removing the person from the United States. And then under the 8th Amendment, we argued that anytime the government decides that they're going to incarcerate people, that they need to provide safeguards for the physical well-being and security of those who they are incarcerating, whether or not they know what those risks are. And here, there was no question that the Wyatt and ICE knew that COVID eventually was going to make its way inside of the Wyatt, because there was no social distancing that was happening at the Wyatt at the time. And this was late March, early April. Visits were still going on. I, as an attorney, was going in and out of the facility. And when I was walking in, officers weren't wearing masks. Nobody had gloves. There was none of this you know, that we see now that's become normal. Everybody wears a mask. They check your temperature anytime, you know, you go into any facility. There was none of that happening. And there was also no social distancing. So when we had talked to the detainees inside of the Wyatt, under the first case, under the Medeiros case, which was 3 of the immigrant detainees, we were being told that at the time there were 71 detainees when we first started the Medeiros case inside of the Wyatt. I'm lying, there were 80 detainees, and then they had deported 9 of them. Then there were 71 by the time we filed the second case, which was the Giannis case that got filed in May. The first case, the Medeiros case, was not a class action lawsuit. It was a habeas petition that was being filed for 3 individuals, like any other habeas would have been filed. And we really lucked out. Judge Smith, well, I'm not going to say we lucked out. We advocated appropriately, I thought. It wasn't luck, it was good advocacy on the part of, you know, of my colleague Jared and ACLU National, and of myself, and all the work that had been done. And what we argued was that there was no social distancing going on inside of the Wyatt, number 1. Number 2, that wasn't even possible. At the time, as I said, there were about 80 detainees in one pod. And what the pod looks like inside of the Wyatt, if you can imagine it in your head, much like you see on TV, the perimeter of the pod itself, well, the pod itself looks like a big gymnasium, like a basketball gymnasium sort of thing. And around the parameters are the cells, and there's 50 cells, 25 on top, 25 on the bottom, and each cell holds 2 detainees. So if there are 80 detainees, and the cells are about 5 feet by 9 feet, holding 2 people at a time, with bunk beds that were less than 3 feet apart. So there's one bed, there's 3 or 4 feet, maybe 3 or 4 feet, and then the other bed. So there's no social distancing going on at all inside of the actual cells. But then when all of the detainees were coming out at mealtime and at rec time, definitely no social distancing going on, because it was impossible. There was just no room inside of the pod for that to happen. And that was basically what we argued in the Medeiros case. And we were successful. Judge Smith immediately saw that there was no way that the Wyatt was going to be able to secure the safety of the detainees with the threat of COVID going around in various other detention facilities. And the CDC had been very clear that the only way to keep or to not spread the virus was to exercise social distancing and wear masks and wash your hands regularly and not touch your face, and all of the warnings that we had been receiving and we still receiving today to keep to not spread the virus. And so Judge Smith, within, I think we filed our lawsuit, and within 10 days, all 3 of our plaintiffs had been released. So of course, you know, word spread inside of the Wyatt that we were successful with these 3 plaintiffs. And I, for one, had been receiving numerous phone calls from other detainees that were inside of the Wyatt that were also at high risk of contracting the virus due to underlying conditions, because the CDC has said that people who have asthma, people who have heart conditions, in some instances hypertension, could have a more severe, what's the word I'm looking for? In other words, that person could get more severely sick than someone who is healthy. Even though now we're hearing that even if you're healthy, you know, the chances of you contracting the virus are just as high. But at the time, that's not what we were hearing, and the 3 of our plaintiffs had all of that, and Judge Smith released. And then I received a slew of phone calls from detainees at the Wyatt that had hypertension, that had heart conditions, that were suffering from anxiety and asthma. And it didn't take long for the team, and when I say the team, I say, you know, myself, Jared Goldstein at Roger Williams, Morgan Russell at ACLU San Francisco, and Lindsay Cayley at ACLU New York, for the 4 of us to come together and say we really should be filing a class action lawsuit. And lo and behold, it didn't take us long at all to find more plaintiffs who could serve as the lead plaintiffs in the class action case. And we had filed that on May 15th. So all of this started with the Medeiros case back in early April. So a month later now we're filing. And what was really striking was that when we first filed our lawsuit for the Medeiros case, the first 3 plaintiffs, I think the Wyatt maybe had been reporting, at the time I looked at my records. So I guess let me back up for a minute. Before we actually filed the Medeiros case, private attorneys were filing habeases for their own clients in their own cases. And there had been a case at the Rhode Island District Court called Salage, I believe it's Salage v. Martin as well. And Judge McConnell had that case. And within the context of that case, Judge McConnell ordered that the Wyatt provide reports on a weekly basis as to the number of detainees that are inside of the Wyatt, and also, you know, what was testing looking like, what was PPE looking like, you know, what was social distancing looking like, what was the Wyatt doing to prevent the spread of COVID? Well, as a result of those reports, we were able to secure a lot of great information. And what was striking by the time we filed Giannis, which was the class action lawsuit that we filed to protect all of the immigrant detainees that were being held at the Wyatt by ICE, was that in April 20th, the Wyatt had reported that it had done only 2 COVID tests inside of the facility, and both of them had been negative. Less than 4 weeks later, the Wyatt reported 38 positive cases. So COVID inside of the Wyatt was running rampant. Today, I just checked the last report that I saw that had a July 23rd date on it. They've done 1,600 tests since July, so 3 months ago, right? So within the 3-month period, they're doing about 400 tests a month, and there's now 58 positive cases inside of the Wyatt today. One of the other issues that we argued in the Wyatt was that the Wyatt has no capacity as a facility to separate or segregate detainees who were sick. So when detainees were being sick, where were they going? And the Wyatt, you know, tried to find a way, and eventually they ended up putting folks in another pod, but there was no question that Wyatt had no way of securing the safety and the health of the detainees, the immigrant detainees that they were holding. And it didn't take long for Judge McElroy, who's a judge who is hearing the Yanis case, to provisionally certify the class. So we filed our lawsuit on May 14th, and by May 20th, she had certified the class. We'd also filed a preliminary injunction to get to not allow immigrants in or out of the Wyatt. She didn't go that far, but did require require ICE to inform the court when it is that they were moving people out and when they were moving people in. So we at least have that. And the case is still going on today. And it wasn't long after that that she, three issues were coming up. Number one, to certify the class. Number two, to start individual bail hearings so that we could try to get these detainees released. And then number three was our preliminary injunction, which has not yet been ruled on, but she did provisionally certify the class, which was great. And she did also order the individual bail hearings, immediate individual bail hearings of the ICE detainees, the immigrant detainees that were at the Wyatt, and that started on or about June 2nd. By July 4th, so June 2nd, she orders that she's going to start individual bail hearings, and we had just that. There were 4 attorneys. Actually, the law firm Morgan Lewis became one of our partner firms in this case as well. So they became part of the class action lawsuit team. And Morgan Lewis has done really a phenomenal job at kind of like keeping documents organized, because we had to obtain all sorts of medical records and criminal records from all of the immigrant detainees that were inside of the Wyatt. But hearings were individual. So each one of us, each one of the attorneys took on, however many detainees we could, and we prepared bail hearings and gathered documents and talked to families and secured release plans and did whatever we could in a very short period of time. Judge McElroy was holding hearings on a daily basis starting, I think it was June, like the week of June 2nd. It was immediately after her decision. And we were having hearings daily from June 2nd until just before July 4th. And every day she was hearing 4, on a good day it was 5, on a bad day it was 3. But all of us were really, working around the clock to try to get these bail hearings together. And God is good. And I don't know if I can say that to the ACLU, I'm sorry. But, we were able to release 28 people. This is great news, because we cut in half the population that was at the Wyatt. So I said the case started with 71 immigrant detainees. ICE then removed 12 of them as a result of the judge's order that they needed to let the court know that they were going to remove folks. And unfortunately, whenever ICE informed the court that they were going to be removing, the likelihood of us winning a bail hearing went down like 90%. She was never going to release them because ICE was saying we're removing them on a certain date. So by the time we actually started bail hearings, we had 58 plaintiffs, 58 clients, class members. We were able to release 26 of them. It was either on ICE's own recognizance, right, that ICE decided, because the court also ordered that ICE make sure that they really review the records of each client and determine whether or not that person really needed to be detained, or could they release them on other secure grounds, like maybe an ankle bracelet or home confinement or something like that. But we really reduced the number of ICE detainees as a result of this litigation. Today, we started with 71. Today, there are 28 detainees, ICE detainees. So there's plenty of room now, at least for social distancing. Now, I'm not for detaining immigrants. I don't think that's what we should be doing as a nation. But since my word doesn't matter, and they're going to be detained, I think it's good that at least they have the ability to social distance. And since this litigation has started, the other thing we've been able to do is to secure PPE, so that on a weekly basis now, detainees are receiving masks, they're receiving soap, there's hand sanitizer now that has been placed within the pod where detainees are free to, at least be able to wash their hands and social distance. Also, the Wyatt has staggered meal time and recreation time as a result of this litigation, so that they can ensure the safety of the immigrant detainees that remain at the Wyatt today. This has been an incredible experience for me as a professional and as a human being to be able to help all these people. So thank you, Steve, for calling on me and trusting me to be able to do this work. Thank you.
Thank you so much, Debbie. That was really great. And it was great to hear the insider perspective too. So now we're gonna have Hannah join us to bring us up to speed on some of our recent work related to student rights. It's both student rights and racial justice. Those two things intersect. So Hannah, why don't you take us out? Hold on, let me spotlight you. There we go.
Thanks, Nicole. Hi, everybody. My name is Hannah Stern. I'm the Policy Associate at the ACLU of Rhode Island, and thank you all so much for joining us this afternoon. I'm really excited to talk to you today, as Nicole said, about our work on students' rights and racial justice, especially in the last few months. And this is really one of the major topics that, as an affiliate, we've worked on for literally decades and continue to follow closely. And this issue has also really been in the public eye lately, especially after such an upswell of support for addressing racial inequity in education and the disparities involved in discipline data statewide. As many of you probably know, addressing these really highly discriminatory disciplinary rates is an issue of racial justice. So just for some background information, our Rhode Island state law does require every district to report their discipline data, and it's aggregated and reported depending on the age of the student, what school they go to, what district they're in, and the race of the student, and also if the student has a disability or not. So there's a lot of really important factors that are reported by each district when it comes to their disciplinary data. And it also requires, state law also requires districts to analyze this data independently for disproportionate rates of discipline relative to the population of a certain demographic of students in school. So, and it requires them to submit a report if this disparity is detected. As I said, we've been analyzing this data for years, and we've consistently found that every single district in the state of Rhode Island displays a disparity in some respects. So whether they're over-suspending students with disabilities or they're over-suspending students of color, often over-suspending both of these groups at the same time. And then we also see that students of a really young age are being affected by discipline rates to a really concerning degree. And then the last thing that we're also consistently finding is that no districts are taking accountability in the way that they're legally supposed to for these rates and submitting these required reports, indicating that they're actually looking at the discipline data that they're reporting. So just in one example, last August, we sent a letter to Providence Public Schools that noted that in our analyzation of the data for the 2017-2018 school year, the group of students most severely affected by disparities in discipline rates were Black students in grades kindergarten through 5th grade, which is a horrifying fact, and even more concerning because suspensions at this age are really only counterproductive and harmful, right? It's hard to imagine an instance where a kindergartner is displaying insubordinate behavior to the degree that they need to be removed from the classroom for an extended period of time. If anything, these students should be provided behavioral support by schools. So this last legislative session, which was obviously impacted by COVID-19, we did support and introduce legislation which would have required school districts to confront these disparities that they're consistently showing and would have prohibited out-of-school suspensions for students in 5th grade and below. But as with many other very important pieces of civil liberties related legislation, the progression of this bill was stymied by the pandemic. So this issue is particularly salient and really is only compounded by the really concerning misconduct that we see perpetrated by law enforcement officers in the role of school resource officers or SROs in schools. And this has also been a topic which has really been in the public eye in the last few months. And actually in the last 2 months, our affiliate filed 2 lawsuits over unlawful arrests by SROs on Rhode Island public school students. In one, a special education student in Narragansett was thrown to the ground by an SRO and subsequently arrested just for being disrespectful. And in another, a 13-year-old female Black honors student in Pawtucket was unlawfully arrested by an SRO who students actually claimed had been saying previously in the school year that he was, quote, itching to arrest someone, which I've repeated that statement, I feel like 100 times since this lawsuit was filed, and it never gets more less disturbing to say that. So what we see is that both these disciplinary rates and this SRO involvement contribute to the school to prison pipeline, which is a term that kind of encompasses the disproportionate impact that students of color face within the criminal justice system that starts with these incredibly harsh and overzealous disciplinary and policing policies in our public schools. Rhode Island currently provides reimbursements for schools to hire SROs and to bring law enforcement into our public schools. We supported a budget item this year that was put in the Governor Raimondo's fiscal year 2021 budget, which would extend the reimbursement structure that's currently available to SROs to mental health professionals instead, so that schools can choose to hire an additional counselor or an additional social worker or a psychologist rather than bringing law enforcement into schools, because this really just reflects what students actually need, especially with the perspective of a global pandemic, which is undoubtedly traumatic for students, and especially with these very publicly documented horrible incidents of police brutality that we've seen nationwide. Students need this comprehensive behavioral and mental support. They don't need harsh disciplinary policies, and they certainly don't need police in schools. So many of these campaigns are ongoing, and they'll continue for a while, but issues of school equity and school discipline and SRO misconduct continue to be central to our racial justice work and are still extremely relevant as we continue to navigate this pandemic. So thank you for your time. I'll turn this back over to Nicole, and thanks again for joining us.
Hi, thank you so much, Hannah. That was great. So finally, I know a lot of people are curious about police accountability given what's going on across the nation. And so I know Steve has a brief update on a recent incident in Rhode Island, which highlights sort of the true breadth of this particular police accountability issue from a civil liberties perspective. Steve, can you tell us a little bit about the Columbus statue vandalism arrest?
Yeah, so, yep. So we all know what's going on both in Rhode Island, across the country. There's just been this tremendous interest in holding police accountable. There's the whole defunding, divesting of police initiative that's going on, protests every week. You know, it's great to see this, this surge of interest in holding the police accountable. But one thing that I think it's important to emphasize is how difficult it is going to be to really stop a lot of the police abuses that are going on. And I just want to give one example that in the middle of all this legitimate outrage about what police are doing, there was an incident in Rhode Island, in Providence, that probably all of you know about, where 3 individuals threw paint at the plywood covered statue of Christopher Columbus in a section of Providence. Now, whatever you think of the vandalism, it was throwing paint on plywood, but each of these individuals was charged with a felony, and a ridiculous felony. The felony was desecration of a grave. Now, I know, the police knows, everybody knows, these individuals are never going to be convicted of a felony. But the idea that police have the power to charge somebody with such a ridiculous crime, to know that they are going to forever know that they were arrested for a felony, and to do it in the middle of all this outrage about overreaching by police is just incredibly disturbing. And I think it's a warning shot to us of how we can expect police, some police departments, certainly some police officers, to try to thumb their nose at what's going on. I think we really are going to have to be very vigilant to address these things that may go under the radar of most people, but that really indicate how serious the problem is and how many different ways you really need to address police accountability in order for it to be meaningful. So I'll turn it back to you, Nicole.
Thanks. Beverly has a question. Aside from providing financial support, is there something we can do to move the issues? This sounds like a Hannah question. Hannah handles our advocacy and organizing, so.
Again, yeah, that's a really great question, and actually is especially relevant to the budget item that I was talking about, because I think one of the really big things that is really impactful is when you talk to your elected state representatives, just voicing support for civil liberties positive legislation and policy is hugely impactful. And I mean, Rhode Island is a very unique state in that it's super easy to be involved in our state politics just because of our geography, and it's also really powerful when people do that. So that's something I would really encourage. And actually, if you're interested, you can still advocate for the mental health and behavioral health support personnel budget item if you're interested. You can contact our office and I can help you. I can set you up with some information so that you can do advocacy to your state representatives and state senators on this budget item, because the budget is one of the only things that our legislature is still talking about. So I'd be happy to talk to you about that further, but I think that really the biggest thing is just voice support for the legislation that promotes civil liberties and the policies even with in your town council. And advocacy in that end is just really important, I think.
Thank you. Thank you everyone for all of our panelists and all of our participants. I think we have to close.